The first panel concerns the national security law from a comparative perspective. And to the credit of the organizers, this tells us that there is value in looking beyond Hong Kong to understand the national security law within Hong Kong. And in today's panel, we will be looking at both foreign cases and foreign law. And I think that value can be seen in three respects. Because when one looks sort of beyond the border, one would see firstly that probably all other countries have national security law in one form or another. Secondly, we would see that that national security law of the foreign jurisdiction is developed in response to the local circumstances, whether it be the so-called troubles of Northern Ireland or anti-terrorism after September 11th. It is responsive to the particular risks and issues that arise in a local jurisdiction. And that, of course, means that those risks and problems evolve and they change. And hence, the laws also have to evolve and change. And it's why it's no surprise now that many countries are at present looking at new national security laws that will amend or enhance existing laws. And the third respect of why it is useful to look at the laws of other jurisdictions is that, again, it will come as no surprise that this tension between security and individual rights and freedoms is the tension that exists in all other jurisdictions. And so there is great value in looking at how, whether it's the courts or the executive branch or the legislative branch, and seeing how these organs have balanced this tension and struck a balance between rights and security. Now, with this introduction, I'm very, very pleased to introduce our two distinguished speakers who are extremely learned in the law, and particularly in this area of national security. Both of them are senior counsel in Hong Kong, so we're very fortunate to have their contribution today. Our first speaker, well, in fact, both speakers need no real introduction. They are very well known to the legal community in Hong Kong. Our first speaker, Mr. Grenville Cross, senior counsel, is vice chairman of the International Association of Prosecutors. Also, we all know a former director of public prosecutions. And I'm very pleased to also say that he's an honorary professor in our faculty at the Hong Kong University. And in his presentation, he will be looking at the topic of non-jury trials or mode of trial for national security cases. Our second speaker is Mr. Robert Lee, Senior Counsel. Again, really well known to our legal community. More than 20 years with the Department of Justice. So the two speakers were former colleagues. But has, of course, been at the private bar and is very well known for his cases in commercial law, corruption law, and particularly in the area of money laundering, with whom I've had many discussions with Mr. Lee. So at this point, I'm going to call upon Mr. Cross to give his presentation.
Good morning, ladies and gentlemen. I am most grateful to the Secretary for Justice for inviting me to participate in today's forum, and I propose to share with you my thoughts, as Simon has indicated, on how the jury system operates in national security law trials, and to make some comparisons with other jurisdictions, both civil and criminal in nature. Now, in order to set the scene, in 2010, 10 years before the advent of the national security law for Hong Kong, the Hong Kong Court of Final Appeal Committee explained that, in the words of the Chief Justice, Andrew Lee Kwok Nung, that it is clear that there is no right to trial by jury in Hong Kong. Now, although the basic law provides that the principle of trial by jury previously practiced in Hong Kong shall be maintained in Article 86, the national security law recognizes that insofar as national security cases are concerned, a jury trial may not actually be in the interests of justice. Although a jury trial is certainly not excluded, circumstances can arise where an alternative means of achieving justice is necessary, and it does not impinge upon the fairness of the trial. Where, therefore, the Secretary for Justice issues a certificate directing that the accused be tried without a jury on the grounds, quote, of, among others, the protection of state secrets, involvement of foreign factors in the case, and the protection of personal safety of jurors and their family members, close quote, the case shall be tried, quote, in the court of first instance without a jury by a panel of 3 judges. That's Article 46. Now, although 3 factors are specifically highlighted as justifying a 3-judge trial, the phrase, among others, is noteworthy and has attracted little, if any, comment. It is presumably a catch-all provision, and it suggests that the 3 criteria are not exhaustive, and that there may be other circumstances that justify a non-jury trial. Although I've not found it easy to envisage what they might be, they could perhaps arise if, for example, the Secretary for Justice concludes that jurors and their relations will face dangers unrelated to their physical safety, such as blackmail or other types of intimidation, or where attempts to interfere with witnesses are anticipated. In all likelihood, therefore, the other grounds are likely to concern matters that affect the integrity of the trial, although they will likely be very rare. Now, I'd like to turn to the Secretary for Justice's certificate. Now, after the Secretary for Justice has issued the certificate, that is normally the end of the matter. Once the Secretary concludes, for example, that the jurors or their family members are under threat, there is a real risk that a fair trial by jury is no longer possible, and the only realistic remedy is a non-jury trial by a 3-judge panel. As the Court of Appeal has explained in Tong Ying Kit's case, the Secretary's decision is a prosecutorial decision within the ambit of the Basic Law, which stipulates that the Department of Justice shall control criminal prosecutions free from any interference, Article 63. The Court of Appeal was also at pains to emphasize that the jury trial is not the only means of achieving justice in the court of first instance, and that the bulk of criminal cases are tried by judicial officers sitting in the district court and the magistrates' court. Indeed, in light of that, it would have been perfectly consistent with the practice in the lower courts for the drafters of the national security law to have decided that national security trials in the court of first instance would also be tried by a single judge, and nobody could seriously have complained. However, in their wisdom, and undoubtedly to allay concerns, the drafters decided that if a national security case was not going to be tried by 7 jurors, then a 3-judge panel was the preferred alternative, presumably reasoning that, as with the Court of Appeal, 3 heads are better than 1. Now, be that as it may, the Secretary's decision to issue a certificate is, like other prosecutorial decisions, amenable to judicial review. As the Court of Appeal has explained, the Basic Law's Article 63, protection against interference, is directed at interference of a political nature. And although judicial interference with a prosecution decision is precluded, This is subject to issues of what was referred to in the case of Ray C and a bankrupt, issues of abuse of the court's process, and possibly judicial review of decisions taken in bad faith. So what this means, therefore, is that although the judicial review of a decision to issue a certificate is exceptional, it is nonetheless only possible in limited circumstances, as where it can be shown that the decision was taken in bad faith, or it resulted from an unlawful prosecution policy, or was otherwise perverse. Even if a judicial review succeeded, its only consequence would be to require the Secretary to reconsider the need to issue a certificate, and not to direct that there be a jury trial, although a jury trial in those circumstances might certainly be a possibility. Now let me turn to the issue of the human rights protections. And I think it's important, ladies and gentlemen, to stress that irrespective of whether a national security trial in the court of first instance is tried by a jury or a three-judge panel, the accused enjoys exactly the same rights to a fair trial for two main reasons, one in the basic law and the other in the national security law. By virtue, firstly, of the basic law, Article 39, the International Covenant on Civil and Political Rights remains in force in Hong Kong, and this, domesticated as it has been through the Hong Kong Bill of Rights Ordinance, protects the fundamental criminal justice guarantees to which an accused person is entitled. It also stipulates that somebody who has been lawfully arrested shall, quote, have the right to a fair trial by the judicial organs without delay and shall be presumed innocent until convicted by the judicial organs. That's Article 87. So although, therefore, the basic law is already very clear in terms of the protections it upholds, the national security law, secondly, goes out of its way to place the fundamental rights of criminal suspects at the front and center of its operation. It not only stipulates, quote, that human rights shall be respected and protected in safeguarding national security, and that the ICC's provisions shall be protected, see Article 4, but it also requires that the principle of the rule of law shall be adhered to, Article 5, and such things as legal certainty, the presumption of innocence, and the right of defense are singled out for a special mention. So, quite simply, therefore, Hong Kong's criminal justice system is human rights heavy, with fundamental protections being repeatedly stated. And this provides a context, I think, for the consideration of national security trials in other jurisdictions. So let me say, firstly, something about trials in the Far East. As Hong Kong has been criticized for making a provision for trials by a three-judge panel in certain limited circumstances, it is, I think, instructive to briefly consider what role juries have to play in three other former British colonies in this part of the world. In Singapore, the legal system is also based on the common law legal system of England. Trials, however, whether involving national security or other types of crimes, are conducted by a single judge, with trial by jury having been abolished in 1969. The country also retains the death penalty, and the authorities can deploy preventive detention of suspects of up to 2 years, which may be renewed in cases involving the country's internal security. Judicial review of decisions taken under the Internal Security Act are only possible in relation to ensure procedural compliance, and Singapore is not a party to the International Covenant on Civil and Political Rights. Now, turning to Malaysia, the legal system there is predominantly based, again, on the English common law, although there are also secondary legal systems affecting particular legal areas, such as Islamic law and customary law. As in Singapore, trials, whether involving national security or other types of crime, are conducted by a single judge, with trial by jury having been abolished in 1995. Provision is also made for the preventive detention of suspects and for the denial of bail to those charged with national security offences. The death penalty still exists, and the country, again, is not a party to the ICCPR. In Brunei, Darussalam, the legal system is based largely on the English common law, although there is also a Sharia court that deals with Islamic law. Trials of whatever type are conducted by single judges without juries, and the courts can impose the death penalty. As with Singapore and Malaysia, the country is not a party to the ICCPR. It is intriguing to note, therefore, that although some people in the United Kingdom, together with some of its global partners, are only too happy to single out for criticism one former British colony, Hong Kong, for having limited the right to trial by jury in national security cases only, they have nothing to say whatsoever about 3 other former British colonies in the Far East which do not have jury trials for any type of offences, whether involving national security or otherwise. Were I not the charitable observer that I am, I might have been tempted to describe this as hypocritical and to conclude that their concerns have been fabricated in order to embarrass China. But please draw your own conclusions. Enough, however, of former British colonies, and let us now turn to the United Kingdom itself. In the United Kingdom, the Supreme Court has taken the view in the Dennis Hutchings case, which I'll refer to again shortly, that although there is a right to a jury trial, it is not absolute, and it may be constrained in particular circumstances by express legislation. It explained that if a trial by jury would place the fairness of the criminal justice process at risk, the right to a jury trial must yield to the imperative of ensuring that the trial is fair. If there is a trial by a single judge, all that has changed, said the Supreme Court, is the constitution of the tribunal, and the fairness of the trial itself is unaffected. Quite clearly, therefore, there has to be fairness to all sides, and the requirements of a fair trial are not determined by the defendant's interests exclusively, and it is in everybody's interests that serious criminal offences are not only thoroughly investigated, but also properly tried. Now, against this background, it has been recognised by the UK that there cannot be a fair trial if the jury has been corrupted. After all, said the Court of Appeal of England and Wales, in the case of Twomey, verdicts by a jury which has been nobbled cannot represent true verdicts. In 2003, therefore, the United Kingdom enacted the Criminal Justice Act, which enables a trial to be conducted without a jury if the judge is satisfied that, quote, a real and present danger exists of jury tampering, and that even if steps are taken to neutralise the threat, the likelihood of it occurring would, quote, be so substantial as to make it necessary in the interests of justice for the trial to be conducted without a jury. Now, even in the absence of concrete intelligence that jury tampering is contemplated in a particular case, evidence that a defendant has previously been involved in any such activity would suffice, as also would evidence that he had previously been tried on some other occasion and interfered with a witness. Now, in 2021, at the same time as Tong Yin Kit was making history by becoming the first defendant to be tried on national security charges here in Hong Kong by a 3-judge panel, a former British soldier, to whom I've already referred, Dennis Hutchings, aged 80, was facing trial for far graver offences by a single judge in a non-jury trial in Northern Ireland, although this was largely ignored by the international commentators who took such great interest in Tong's situation. Hutchings was accused at Belfast Crown Court of attempted murder and causing grievous bodily harm arising out of a fatal shooting during the so-called Troubles in Northern Ireland in 1974. However, he unfortunately died suddenly of a heart attack and the trial was aborted, but his experience is illuminating. In Northern Ireland, there is a long history of sectarianism that has sometimes spilled over into terrorist activity, and it is sometimes necessary to dispense with juries, and this is still possible under the Justice and Security Northern Ireland Act of 2007. And when this happens, the trials are conducted by one judge only and not by 3, as in Hong Kong. These non-jury courts are known as Diplock courts, after Lord Diplock, the judge who first recommended them, and they handle particular offences. They were first introduced in 1973, and at their peak, over 300 trials a year were being held without a jury. The Director of Public Prosecutions for Hong Kong, the DPP, can, if he considers there is a risk of jurors being intimidated, certify that a trial on indictment should be tried by a single judge, which is exactly what he did in the Hutchings case. In 2017, for example, the DPP issued 22 certificates for a non-jury trial. The DPP, however, can only issue a certificate requiring a defendant to be tried without a jury if he fears the administration of justice might be impaired by a jury trial, and he suspects that one of 4 criteria is met. 3 of these conditions involve proscribed organizations, meaning terrorists, while the 4th is that the offense was, quote, committed to an extent, whether directly or indirectly, as a result of, or in connection with, or in response to, religious or political hostility of one person or group of persons towards another. Now, at the time, the British government explained that this condition 4 was needed having regard to recent sectarian rioting, and prosecutors might not be able to prove that a defendant involved in such violence belonged to a prescribed organization. After the DPP had issued a certificate preventing Dennis Hutchings from being tried by a jury, he explained his suspicion that the offences the former soldier was facing had been committed, quote, in connection with or in response to the political hostility of members or suspected members of the Provisional Irish Republican Army towards those who believe Northern Ireland should remain a part of the United Kingdom, close quote. Now, like Tong Ying Kit, Hutchings was aggrieved by being denied a jury trial, but when he appealed to the UK Supreme Court, he also got nowhere. As Lord Kerr explained, it was not to be assumed that trial by jury was, quote, the unique means of achieving justice in the criminal process, and that a jury trial can, in certain circumstances, be antithetical to a fair trial. When those circumstances arose, the only assured means, said the judge, of ensuring that the trial is fair is that it is conducted by a judge sitting without a jury. And in 2015, when the Judicial Committee of the Privy Council considered the issue of non-jury trials in a case arising from the Turks and Caicos Islands, a British dependency, Lord Hughes said this: an order for trial by judge alone can be made where the interests of justice require it, just as in England it can only be made where it is necessary. Now, it should be noted here that precisely the same considerations apply in Hong Kong under the national security law, and a trial by judge alone can only be directed where this is justifiable in the interests of justice, and even then, only in cases where national security is involved. Let me turn next to the situation in Australia and New Zealand. Although the Australian Constitution provides for the trial on indictment of any offence against the law of the Commonwealth to be by jury, a trial by judge alone is permissible in some circumstances in various of the country's constituent states. In New South Wales, a trial without a jury has been possible since 1986, but only if the accused person agrees. If the prosecutor disagrees, a trial by jury can be ordered if deemed to be in the interests of justice. If, however, substantial interference with jurors is anticipated and the risk cannot be mitigated by other means, a jury trial may be dispensed with. In Victoria, state of Victoria, since 2009, a trial without a jury is also possible, provided the accused person agrees and the court considers it in the interests of justice. In Western Australia, since 2004, a jury trial can only be replaced with a trial by a judge sitting alone if the accused person consents and it is considered to be in the interests of justice. In Queensland, since 2008, a trial by judge alone in lieu of a jury trial has been possible if it is in the interests of justice, or because of the case's length and complexity, or because the trial is likely to be unduly burdensome for a jury, or because of the risk of jury intimidation, or because a significant risk exists of pre-trial publicity affecting the jury's deliberations, and the accused person cannot exercise any veto power. Now, in New Zealand, there have also been concerns over jury tampering, and this has resulted in legislation that mirrors the United Kingdom's. The Criminal Procedure Act 2011 of New Zealand enables the court, upon the prosecutor's application, to order that a defendant be tried by a judge alone, without a jury, if there are reasonable grounds for believing that intimidation of potential jurors has occurred or may occur, and that the effects of that intimidation can only be effectively avoided by so ordering. Intimidation apart, the Act also enables the judge to order that a trial be conducted by a single judge rather than a jury if it is likely to be lengthy and complicated. Turning now to the Republic of Ireland. We've already looked at Northern Ireland, so it's instructive, certainly, I think, to look at the Republic of Ireland, not least because some of the provisions in relation to the conduct of national security trials are strikingly similar to those now operating in Hong Kong. In Ireland, the right to jury trial is granted by the Irish Constitution in Article 38.4, although it is not absolute. The Constitution allows the Parliament or the Dáil to establish what are called special courts with wide powers when the ordinary courts are inadequate to secure the effective administration of justice and the preservation of public peace and order, Article 38.3. And in 1972, shortly after what were known as the Troubles erupted in Northern Ireland, the Special Criminal Court, or SCC, was created to handle terrorism-related crimes, invariably involving the Provisional Irish Republican Army, known as the Provos. If a case is tried by the SCC, there is no jury, and the defendant, as in Hong Kong, is tried by a three-judge panel. It is up to the Director of Public Prosecution to decide if a case should be tried by the SCC, and he's not required to provide reasons for selecting this venue. His decision is final and cannot be challenged, save perhaps on the grounds of bad faith, which is virtually impossible to show. Now, even though the Troubles in Northern Ireland formally concluded with the Good Friday Agreement of 1998 and the declaration of a ceasefire by the Provos, the SCC has remained in operation ever since. Not only that, its remit has been expanded, and it now handles not only cases that threaten state security, but also those that endanger the administration of justice, as where jurors face intimidation. And the SCC is also used nowadays to try cases involving serious and organized crime, which of course is way beyond anything that is possible in Hong Kong. By way of example, in 2013, a gang leader from Limerick called John Dundon was convicted by the SCC of the murder of a rugby player, Shane Geoghegan, whom he had mistakenly identified as a rival, and he was sentenced to life imprisonment. Again, after the murder of an investigative journalist, Veronica Guerin, in 1999, the members of our narcotics gang were tried for her murder in the SCC. Cases of this sort, of course, must be tried by a jury in Hong Kong, where restrictions on jury trials in the court of first instance are strictly limited and can only occur, as we've seen, in national security cases. So it is, I suggest, extraordinary that the Western countries that have so much to say about the use of three-judge panels in national security cases in Hong Kong have nothing to say about the use of three-judge panels in general crime cases in Ireland. And again, the double standards are startling. Now let me turn to Europe and the European Court of Human Rights. Although various trial models exist in continental Europe, Greece's, I think, can usefully be highlighted. It was the first country to develop the jury trial, and it still retains its distinctive form. By virtue of the Greek constitution and the code of criminal procedure, felonies are tried by what's called a mixed court, that consists of 3 professional judges and 4 lay judges who determine the facts and also the appropriate penalty. However, some serious felonies, including terrorism, are not tried by a mixed court, but by the judges of a 3-judge Court of Appeal, sitting at first instance, and by the 5-judge Court of Appeal at second instance. And this approach has passed muster. In 2003, for example, members of the so-called revolutionary organization November 17, a far-left urban guerrilla grouping, were judged by the Greek Court of Appeal, the reason being that the felonies of terrorism and organized crime fell within the jurisdiction of the Court of Appeal and not the mixed court. As in the Republic of Ireland, therefore, the jury trial can be dispensed with in not only national security cases, but also in serious crime cases. And this, therefore, goes way beyond anything that is permissible in Hong Kong. Nobody, and certainly not those who whip themselves up into a frenzy over Hong Kong's arrangements, appears to be particularly upset by this, presumably because European jurisprudence has no problems with denial of jury trials. Although the European Convention on Human Rights guarantees the right to a fair trial in Article 6, the European Court of Human Rights has indicated that a state enjoys considerable freedom in choosing the actual means of ensuring this. The Court has also explained that while Article 6 of the Convention provides the right to a fair trial, it does not specify the trial by jury as one of the elements of a fair trial hearing in the determination of a criminal charge. See the case of X and Y versus Ireland. In other words, the Court has made clear that there is no right under Article 6 of the Convention to be tried before a jury. See the case of Toomey. What this means, therefore, is that when there is an appeal, the Court's function is confined to a consideration of whether the system adopted at the trial has contributed to an outcome that is compatible with the European Convention on Human Rights, and determining fairness, its focus is not on the mode of trial itself. Now, by any yardstick, Tong Yin Kit's trial was a groundbreaker for local jurisprudence. On the one hand, it established that while prosecutorial independence is constitutionally protected, the issuing of a certificate is nonetheless judicially reviewable if there are any mala fides. On the other, it showed that the judicial system is capable of adapting itself to new situations, while still upholding the most basic principle of criminal justice, namely the right to a fair trial. All in all, therefore, Tong's trial was a positive experience, with the rule of law being the big winner. Whereas serious national security offences were successfully tried, potential jurors were protected from possible harm, and a panel of experienced judges ensured that the accused person was fairly treated throughout the proceedings. Those who predicted disaster if trials on indictment were not tried by juries could not have been more wrong, and the legal system has, I think, been enriched by the experience. As we have seen, the restrictions that can be placed on jury trials in national security cases are limited and are by no means automatic. They are measured, reasonable, and justifiable, and far more conservative than those available in many other jurisdictions. Despite this, the restrictions have attracted huge foreign interest, invariably hostile, but manifestly hypocritical. It has often emanated from countries that place far more limitations on the availability of trial by jury than is possible in Hong Kong. And they inevitably bring to mind the proverb that those who live in glass houses should not throw stones. In reality, the national security law has not only saved Hong Kong from ruin, but has also provided mechanisms for the trying of cases that are practical, realistic, and above all, fair. Thank you very much.
Thank you very much, Mr. Cross, for that very extensive and useful survey of the law in this area. And I think to many, it's rather eye-opening that there are so many examples of exceptions to jury trial. And just to add to your survey, that the situation in Canada is that you can have judge-alone trials in the Superior Court, although with the election of the defendant, but they are actually rather common, particularly when it comes to commercial crime, because you don't really want the jury to be going through hundreds of bundles of evidence. You also mentioned, Mr. Cross, the issue of jury tampering. One thing you did not mention, and probably another reason why we might want to think about reform in this area, is that in Hong Kong, if a jury acquits someone, it's not possible to appeal that, even if there has been jury tampering. So that gives rise to the problem of unjust acquittals. And it's because of that in 2012 that the Hong Kong Law Reform Commission recommended that maybe we should allow for some appeal mechanism for unjust acquittals. So I think that's also part of the concerns that you've raised. Great. Let us move on to our second presentation. Mr. Lee will be talking about the implementation rules, which sets out a wide array of police powers. And he will be focusing particularly on the power of production or producing documents. And this is quite a valuable discussion because there hasn't been that much attention paid to these police powers under the NSL. Mr. Lee.
Yes. Thank you, Professor Young. Secretary for Justice, honorable guests, ladies and gentlemen, it is my great honor to have been invited to speak in this important legal forum. The topic I'm asked to speak about is this, well, you can see. An overview of Schedule 7 of the implementation rules made under the national security law. The background to my presentation is the national security law and the implementation rules. Just a quick reminder, the National Security Law was enacted by the NPCSC of the People's Republic of China on the 30th of June 2020 and introduced into the HKSAR via the Basic Law to protect national security. The implementation rules were made pursuant to Article 43 of the National Security Law to enhance the investigation of offenses endangering national security. It contains 7 schedules. This presentation examines the effectiveness and fairness of Schedule 7 of these rules. Schedule 7 is entitled Rules Relating to Requirements to Furnish Information and Produce Materials. So it has a rather narrow focus. Does this schedule strike the right balance between effectiveness and fairness? Before descending into technical aspects, let us ask a basic question. Why do countries need to protect their national security, and in what context? National security is the foundation of social order upon which true freedoms and rights of the people, the rule of law, and prosperity and progress can be realized. The national security of all countries requires optimal protection. There are 4 aspects I wish to mention. First, different countries face different existential threats, which can arise from, for example, climate change, extremism, or historical events. It would therefore need to deploy different modes of national security laws and measures to meet their specific national security needs and goals. Point 2, recent centuries of historical development have developed countries into 2 main classes. That is, the developed or dominating countries and the developing or dominated countries. The proper national security goal of the dominated countries is to interact and dissipate the dominating force in order to achieve true universal values. Third point, Western liberalism is a dominating force. It is driven by amoral, ambivalent individual desires. This amoral liberalism has generated centuries of ambivalent results, that is, both good and bad results worldwide. Surely the rule of law, wealth and progress on the good side, but also unending wars, inequalities, social divisions, domination, and dishonesty on the downside. Core liberal values such as freedom, democracy, and human rights, insofar as they are desire-based or desire-driven, are inherently amoral and ambivalent, and not yet true universal values, though they remain promising candidates. True freedom is based on duty, not on desire. The common law is somewhat exceptional in that it promotes rights on the basis of duty. Let us look at the example of right to freedom of movement. Freedom of movement for everyone only arises when everyone, drivers and road users, abides by his or her duties to obey traffic signs and regulations which apply equally to all. When these duties are fulfilled, a traffic order exists. As long as a traffic order exists, everyone can reasonably expect that he or she can move from location A to location B in, say, about 30 minutes, 40 minutes, and in relative road safety. This is my and other road users' freedom of movement. Freedom of movement does not arise from everyone insisting on his or her desire to drive freely that will result in traffic accidents and congestions everywhere in chaos, not freedom of movement. Now, I leave the other two examples for you to figure out. I'll come to the conclusion at the bottom. So I offer this as the duty logic of freedom. Anyone's freedom or right is constituted by everyone fulfilling their corresponding duties and the orders sustained by such duties. Legal and other measures which optimally promote duty or optimally restrain desires do not diminish individual freedom, but are conducive to our freedom and rights. So freedom, democracy, and human rights, to be true universal values, should be duty-based, not desire-based. And the rule of law provides a cogent platform for this transformation to happen. Now, duty can occur at many levels. Great minds in both the East and the West, dating back to 2,500 years ago, have reminded us that our core duty is to achieve mutuality. That is, to respect others as equals, to treat others as ends, not means, and to sacrifice for each other. Coming back to Hong Kong, why protect national security in the HKSAR? As explained above, national security is the foundation of social order within which the freedoms and rights of the people in the HKSAR can be realized. The rule of law can operate, and upon which prosperity and progress can be pursued. Now, under protection of national security creates disorder, harms the rule of law and the freedoms and rights of the people. It also hurts the economic environment, disrupts international trade, and diminishes foreign business interest. So it is to nobody's interest. The national security law is both comprehensive and focused. Among other measures, it sets out 4 types of offenses in its Chapter 3. They are secession, subversion, terrorist activities, and collusion with a foreign country or with external elements to endanger national security. These offenses are specific in their scopes and meticulously defined. Each requires cogent evidence to prove. Fair and effective powers of investigation can ensure that the subsequent prosecutions of national security offenses are speedy and fair. My focus is on the implementation rules. The implementation rules contain 4 rules and 7 schedules. Rule 2 specifies the parties who may exercise the powers under each schedule. Rule 3 specifies that only judges designated under Article 44 of the National Security Law may handle applications under these rules. These rules are important means to enhance effective and fair investigations. There are 2 ground features which makes them conducive to the effectiveness and fairness, which makes the implementation rules effective and fair. The first feature, the implementation rules are largely based upon current investigative measures relating serious crimes, such as corruption offenses or organized crimes. In fact, as we will see in a moment, sections 2 and 3 of Schedule 7 are closely modeled on sections 3 and 4 of the Organized and Serious Crimes Ordinance, Cap 455. That ordinance was first enacted, I believe, in 1994, almost 30 years ago. These current investigative measures have been in use for a long time and have been improved upon as required by practice. By adapting these existing measures as the implementation rules, these rules inherit their legal and practical experience. The second ground feature is this. While the implementation rules have their origin in a national law, they are to be applied in the common law context as required by, among others, Articles 4 and 5 of the National Security Law and Article 8 of the Basic Law. Article 4 of the National Security Law provides human rights shall be respected and protected in safeguarding national security in the Hong Kong SAR. The rights and freedoms, including the freedoms of speech, of the press, of publication, of association, of assembly, of procession, and of demonstration, which the residents of the region enjoy under the Basic Law, shall be protected in accordance with the law. Article 5 of the NSL provides the principle of the rule of law shall be adhered to in preventing, suppressing, and imposing punishment for offenses endangering national security. It is reiterated there that a person is presumed innocent until convicted by a judicial body. And the rights of the defendant to choose his own lawyer is also emphasized. The rights to defend himself or herself and other rights in judicial proceedings that a criminal suspect, defendant, or other parties in judicial proceedings are entitled to under the law shall be protected, and so on. Article 8 of the Basic Law provides the law previously enforced in Hong Kong, that is the common law, the rules of equity, ordinances, Subordinate legislation and customary law shall be maintained. The implementation rules involve using court orders to regulate investigations. In the case of Negla, I hope I pronounced that correctly, Latvia, the European Court of Human Rights takes the view that court orders are in general a more cogent means for regulating criminal investigations. The facts are interesting. The applicant, Negla, worked for the national television broadcaster, where she produced and hosted a weekly investigative news program. In February 2010, she was contacted by an anonymous source who revealed that there were serious flaws in the database maintained by the State Revenue Service. A week later, her source began to use Twitter to publish information concerning the salaries of state officials in various public institutions. In February 2010, the investigative police interviewed the applicant as a witness. She declined to disclose the identity of her source. Then 3 months later, the investigating authorities arrested a suspect called IP. The applicant's home was searched, and a laptop and other items were seized after a search warrant was drawn up by the investigator and authorized by a public prosecutor. The applicant complained that the search of her home meant that she had been compelled to disclose information that had enabled a journalistic source to be identified. She relied on Article 10 of the European Convention on Human Rights, which provides, in Clause 1, everyone has the right to freedom of expression, but then this is qualified. The exercise of these freedoms, since it carries with it duties and responsibilities, may be subject to such formalities, conditions, restrictions, or penalties as are prescribed by law and are necessary in a democratic society. The list, in fact, goes on. In the interest of national security, territorial integrity, or public safety, for the prevention of disorder or crime, for the protection of health or morals, for the protection of the reputation or rights of others, etc. The European Court of Human Rights is of the view that the interference to the applicant's freedom of expression is prescribed by law and with a legitimate aim. I quote, "The court could accept that the interference was intended to prevent disorder or crime and to protect the rights of others, both of which are legitimate aims." However, the European Court of Human Rights notes that a search warrant in vague terms rather than a disclosure order was issued. A search warrant is a more drastic measure, and that questions of confidential sources call for the most careful scrutiny by the court. But the reasoning of the reviewing court in the domestic court was defective, and compensation was awarded to the applicant. She was awarded, 10,000 euros in damages. Now, I suggest 3 types of criteria to assess the effectiveness and fairness of Schedule 7 procedures. I do not have a complete answer, but I suggest these criteria for you to consider. Criteria A deals with Schedule 7 mechanism or procedures. 1, is the scope of the court order effective and the application procedure stringent? 2, are the conditions to be fulfilled before an order can be made stringent? 3, is the implementation of the order likely to be effective in practice? 4, can the affected party object? Criteria B deals with the protection of the rights of the affected parties in respect of legal professional privilege, or LPP. LPP, as in the note shows, protects the confidentiality of bona fide communication between lawyer and client concerning matters of legal advice or in reference to litigation, be it ongoing or in contemplation. The privilege conveys the right to resist the compulsory disclosure of those communications. 2, the privilege against self-incrimination. 3, journalistic material. Criteria C assesses whether Schedule 7 procedures enhance rather than impede the fundamental rules of criminal trials. Namely, the prosecution bears the burden of proof. 2, proof must be beyond reasonable doubt. 3, relevance as the paramount criteria for admissibility of evidence. And 4, fair trial and the right of the defendant to appeal. Improper application of civil principles or standards in criminal proceedings by the defense may thwart a prosecution properly brought. And if improperly applied by the prosecution, may deny a defendant of his fundamental rights to a fair trial or to pursue appeals. Now let's take a look at the structure of Section 2. This is the section by which the court can order a person to answer questions or produce material to the SJ. Maybe a bit difficult to read, but anyway, just listen to me. Subsection 1 empowers the SJ to apply for a court order in the first box. Subsection 2 empowers the CFI to make the order if conditions are met. Subsection 4 sets out the conditions. Subsection 3 sets out the terms of the order. In fact, this is an authorization from the court to the SJ for her to implement the order, which is dealt with in subsection 5. The SJ may issue a notice pursuant to the order, requiring the person subject of the order to answer questions or to produce material. Subsection 9 protects LPP. Subsections 11 and 12 deals with the privilege against self-incrimination. Subsection 13 and 14 creates offenses of non-compliance. And outside this subsection 2, there are section 4 and section 5. Section 4 at the bottom restricts the disclosure of information obtained pursuant to sections 2 and 3. And section 5 sets out a general offense of prejudicing investigation, prohibiting tip-off or other forms of unlawful interference with the investigative procedure. Now, a body of case law has already been building up. In the case of J and Commissioner of Police, the court dealt with an application to discharge a court order. This is a section 3 production order. And we shall see a moment later that this application was rejected on the basis of section 4. Now, is LPP protected? The answer is yes. In the case of A and Commissioner of Police, the court gave effect to LPP protection. The court found that the redacted WhatsApp exchanges in question and the internal emails of A and B were all about an employee seeking legal advice From the legal department, there was not a prima facie case that the items came in existence as part of any fraud or crime. So the court gave full protection to this LPP material. Now, is the privilege against self-incrimination protected? In fact, it has been decided by the CFA some 20 years ago that for investigation into serious crimes, this privilege may be restricted. In the case of Li Ming-chi, one of the issues was whether for inquiry under Section 1451 of the then Companies Ordinance, whether Section 1453 has abrogated the privilege against self-incrimination. The Court of Final Appeal construed the provisions and held that the privilege was abrogated, but it was replaced by a so-called direct use prohibition. The net effect is this: the person subject to the inquiry must answer questions, even if they may be self-incriminating, but which answers cannot be used in evidence against him. Journalistic material. Now, Schedule 7 does not explicitly cover journalistic material. In the case of A and Commissioner of Police, the court took the view that the protection of journalistic material afforded by Cap 1 does not apply. Well, it's not explicitly covered by the wording of Schedule 7. But this is important, but that Article 4 I just read to you of the NSL, which protects human rights, including freedom of expression, press, etc., may afford alternative indirect protection. Now we move on to Section 3, which concerns production orders. It has a structure similar to that of Section 2. There are three differences. In contrast, the lower part. In contrast to Section 2, a Section 3 production order also applies to the investigation of proceeds of crime. And it may cover material outside Hong Kong. If it is intended to obtain overseas material, the application must be made by the Secretary for Justice and not simply by an authorized officer. And thirdly, Section 3 excludes the privilege against self-incrimination altogether. As I said, Section 4 restricts the use of information obtained from Sections 2 and 3 of Schedule 7. In the case of J and Commissioner of Police, the subject of the order sought to vary those orders on various grounds, including the alleged risk that the information would be disclosed to the public. This was rejected by Alex Lee J. There was no basis to worry that the personal data in question, once produced to the police, would be made available to the public. To the contrary, Section 4 of Schedule 7 contains provisions which restricted dissemination of information obtained by the police under those sections. So there is really no basis for to discharge or vary the order on that ground. Now, Schedule 7 also contains various offenses. There are offenses of non-compliance provided by Sections 2 and 3. And it is important to identify who is the subject of the order, because under our system, in principle, only the person who is subject of the order can be found guilty of the offense of non-compliance. Section 3(2) provides, subject to subsection 5, the court may make an order that the person, now notice this phrase, who appears to the court to be in possession or control of the material to which the application relates, must produce the material, etc. So it is the person who appears to the court to be in possession or control of the material will become the subject of the order. Notice also that the person can be in possession or in control of the material. Now, to be guilty of this offense, all the elements of non-compliance have to be proved and subject to the reasonable excuse that the defendant may be able to put up on the evidential burden. This is provided by Section 3, subsection 12. Now, there is also Section 5, providing a general offense of prejudicing investigation. It's a bit complicated, but since you are all law-abiding citizens, I will skip this slide and leave it to Professor Young to enlighten us. Ladies and gentlemen, that concludes my presentation. Thank you.
Thank you very much, Mr. Lee, for that wide-ranging and in-depth presentation on national security and Schedule 7. I thought an important point that you made in your presentation was that the implementation rules, while being national law, is applied in a common law system. And I thought there was room to highlight an important point about the status of the implementation rules, because I see a kind of inherent tension with the IRs in that when you look at the substance, and the point you made, you look at the content of those rules, they are very much based on Hong Kong laws and jurisprudence, and no doubt whoever drafted them probably was well aware of the Hong Kong law. But at the same time, it is a national law, as you highlight. And it might be that someone looking at this from the common law system may think that the implementation rules look like subsidiary legislation, and that the NSL is the primary legislation, and that Article 43 of the NSL looks like the empowering provision. My own preliminary view, and I'd be interested to see what you think, my own preliminary view is that that's probably the wrong way of thinking about it, that the implementation rule is not Hong Kong subsidiary legislation, it's national law, as you say. And so the ordinary rules that we have that apply to subsidiary legislation and the relationship of subsidiary legislation to the primary legislation probably wouldn't apply. I don't know if you've given any thought to that, Robert.
Well, thank you. That's a difficult question. The implementation rules were made pursuant to Article 43 of the National Security Law. National Security Law is definitely a national law, right? So you may argue that anything made pursuant to its provisions also acquire that quality, i.e. a national law. Or I would preliminarily prefer this view. When you say it is in the nature of a national law, it applies to the whole nation. And I'm not too sure that is the case. And perhaps the court or somebody wiser than us can enlighten us later. I tend to think that I would tend to be more prudent on its nature.
Yeah, I think that you make a good point about that. I don't know, Grandpa, if you thought about that.
I haven't seriously thought about it.
No. No worries. Maybe I can ask you a couple questions about your presentation.
Please do, yes.
Now, I'd like to ask you about majority verdicts. And of course, we don't know whether the three-judge panel under the NSL can actually decide by majority, because it's not spelled out in the NSL. We know that when we have jury trials, we can have majority verdicts as much as 5-2. And if you work out the math, that represents approximately 71% of the jury. Now, assuming that you can have majority verdicts with the three-judge panel, 2-1, that's 67%. Is it acceptable to have a 2-1 majority verdict in an NSL case? And what about Ireland? What is their experience where they do have the same kind of configuration of the three-judge panel?
Well, of course, it's been accepted for many years in many common law jurisdictions that you can have majority verdicts. And once the principle has been accepted, I don't think it's necessarily too helpful to break down the exact percentage at the end of the day. But perhaps a way of testing its legitimacy is by looking at the Court of Appeal itself. I mean, the Court of Appeal, for example, in a murder case, can decide to uphold the conviction by a majority of 2-1. And no one suggests that that's an improper verdict in any way. The Court of Final Appeal has even decided cases on the basis of 3-2, if I remember rightly. In the Congo case back in 2011, it was a 3-2 majority to refer the matter for interpretation to the National People's Congress. And the fact it was 3-2, which is, I'm not very good at percentages, but I mean, it must be something like 55, 56 to whatever. It's not necessarily a helpful way of looking at it. In the United States, the case in 2015 concerning homosexual marriage, I mean, that was approved by a huge change in the social order in America. That was approved by a majority of 5-4. So a very tiny majority, but that didn't affect the ultimate legitimacy or the status of the judgment itself, which immediately took effect. I did some studies of the situation in Ireland, and I'm told by people on the ground that they can return verdicts of 2-1, but this is never announced.
Oh, it's never happened.
Well, no, it may have happened, but it's never announced.
I see.
And they deliver a reasoned judgment, but the judgment doesn't indicate if it's unanimous or by majority. There's only one judgment delivered, one verdict delivered by the court. And the general public will never know whether it was a majority or unanimous verdict.
Oh, very interesting.
Yeah.
I was wondering whether the distinction that the examples that you've given of the appeal courts might be distinguished on the basis that, of course, they're deciding questions of law, whereas here the three-judge panel also decides questions of fact, where the fact-finding requires a higher degree of majority consensus. I don't know, but I think the Irish example, I think, is important.
But of course, what matters to the accused person is whether he's ultimately adjudged to be guilty or innocent. Yeah. And whether it's a purely a legal issue or a factual issue doesn't really affect that, does it?
No. Good. A second question I'd like to ask you, Grenville, relates to law reform, because I think as your presentation has very helpfully and powerfully illustrated, there are many jurisdictions, in particular common law jurisdictions, that now allow for judge-alone trials beyond the national security context. Is that a law reform that maybe we should be thinking about here? And how would you set the parameters? Would it be just for specific serious crimes? Would it be at the election of the defendant only? What are your thoughts on that?
Well, of course, it is always a controversial issue to limit the role of juries in court of first instance trials. And in the past, there have from time to time been discussions about having single judge trials for complicated commercial cases. But those have never really got off the ground, the view being taken that unless it's absolutely essential and alternatives can't be pursued to getting rid of jury trials, then you should stick with the jury trials. And of course, the way they've got round it is that courts now prioritize the counsel making things as simple and understandable as possible, and that judges make their summings up as plain and possible as possible, so that the ordinary jurors can understand the issues. But I think it's probably fair to say that in those jurisdictions which have limited the right to jury trials, in, for example, cases where there are problems of jury tampering, or where there's problems of pre-trial publicity, or where the case is of huge complexity, they have done it with some reluctance, and only because they took the view in their particular jurisdictions that this was really essential in the interests of justice. I don't believe we've achieved that position here in Hong Kong. By and large, as I say, in commercial crime cases, an alternative means has been adopted. Even in the days where there were perhaps cases where the triads and other unsavory elements were trying to tamper with juries, the view was always taken that this wasn't a serious problem. That if cases did arise, then the police had the ability to handle the situation, and indeed so did judges if problems arose during the course of a trial. So my understanding is, my view would be that unless there is a pressing need in the interest of justice to change the system here in Hong Kong, then we should stick with what we have at the moment. Even though if serious problems were to arise, as have happened in other jurisdictions, then certainly the issue could be looked at again.
Of course, no doubt we will learn from our experiences with having judge-alone trials in NSL cases to see how that works in practice. And it may well be 3 judges, maybe too much, maybe a single judge, maybe the more ideal configuration if you're going beyond the NSL. And then there's, of course, questions of who decides, whether it's an application to the court or it's the Director of Public Prosecutions.
Well, it would normally come from a party, I think. I mean, presumably the prosecutor would tell the court, we have convincing evidence in this case that attempts are being made to interfere with the jury, and we invite you to order a non-jury trial. And likewise, the defendant might come before the court and say, well, I seriously feel I can't get a fair trial here because there's been massive pre-trial publicity, and that would prejudice my right to a fair trial. So it could come from either side. But if either side could make out its case, then that would be a basis for having a non-jury trial. But as I say, fortunately, we haven't arrived at that situation in Hong Kong. Hopefully, we never will.
No, that's right. Great. Thank you, Grenville. Mr. Lee, I have a couple questions for you. In your presentation near the end, you referred to a provision in the Implementation Rule Schedule 7 that allows the Secretary for Justice to apply for the production of overseas materials. So materials that are outside of Hong Kong, which is rather interesting. So I'm wondering whether if someone doesn't comply, so for example, the custodian of the records overseas, whether they might be liable to conviction. Because I noticed you said that the people who have possession of the documents, if they don't comply, they could be committing a criminal offense. That would seem a rather extraordinary reach of extraterritoriality of the laws. What is your view of the position under the implementation rules?
Well, Section 3 of Schedule 7 provides for the SGA to apply for material overseas, but the order, as I read it, is directed not at the overseas custodian. It's directed at someone in Hong Kong. So, as I emphasized, the person who is subject to order can be guilty of non-compliance, but not someone else. So, my preliminary view is I have no worry. I don't think the overseas custodian should have any worry about being charged by a Hong Kong court. But the pressure, I would imagine, falls all on the Hong Kong party, the Hong Kong person who's the subject of the court order. He or she will have to make great effort, genuine effort, to try to obtain everything which is within the terms of the order.
Good. And in that sense, it seems what you're saying is that power would be consistent with the similar power under the Prevention of Bribery Ordinance, which would have to be, to some extent, territorial, directed at someone in Hong Kong.
Yes, I think I agree with you. I think my reading of Schedule 7 is a criminal jurisdiction, is territorial.
Yes. And again, I mentioned this power under the Prevention of Bribery Ordinance. And of course, we have a case from the Court of Final Appeal named P versus the Commissioner of ICAC. I think most criminal practitioners are familiar with this, that dealt with this production power. And in the court's judgment, it essentially read in an exception to the production of documents if it was oppressive. If it was too oppressive, then that would be a grounds for possible legitimate non-compliance. Now, of course, in the implementation rules, that exception is not explicitly spelled out. Is it your view that that exception would also apply?
Well, P against the Commissioner of ICAC is an important, very important decision as far as Section 14 of the POBO, Prevention of Bribery Ordinance, is concerned, because it examines and applies that section. Section 14 of POBO differs quite a lot from our Section 3 in the implementation rules. So that decision, I would say, may have some marginal relevance to the present case. As I understand it, the Court of Appeal there was saying that once the statutory conditions are satisfied, the court has little discretion not to make the order. It can refuse to make the order if it is oppressive, if in a just view. So the oppressive concept comes in that context. Whereas in Section 3 of Schedule 7, it expressly provides for the, you may call it a defense of lawful authority or reasonable excuse. So in my view, it is open to anyone charged with an offense of non-compliance under Section 3 to raise this defense. Perhaps the oppressive test is not the right test. The right test is whether to ask whether the defendant can raise either lawful authority or reasonable excuse on a very low standard, which is the evidential burden only. So that's the difference.
Thank you for clarifying that. It's a rather complex area, isn't it?
Yes.
We've got a little bit of time left. Why don't we see if our panelists have any final words on this topic of sort of comparative law in the NSL. Any final words you might want to mention? How useful are these comparative cases? Do you think are...
Well, I think once one starts studying the jurisprudence in other jurisdictions, and indeed the legislation, one immediately sees how Hong Kong's legislation is not unique and indeed can be usefully interpreted. And it goes a great way, as I said in my remarks, towards allaying the concerns that some people have felt. The type of problems that we've faced here in Hong Kong have been encountered elsewhere, and other common law jurisdictions have adopted a similar approach to us in seeking to resolve them. And so by understanding the broader global situation, I think this is very helpful indeed. Robert?
Well, from a comparative perspective, there is heavy emphasis in the NSL itself that human rights and rule of law shall be adhered to, etc. And the rules, and the schedules in the implementation rules are basically based on a model on the existing investigative measures. So I would think that the likelihood is that our jurisprudence would be very much on par with the common law system. Personally, I don't have any worry about this law creating really inconvenience or things of that sort to the community.
Right. Thank you. And of course, the law that we create in Hong Kong could well contribute to this broader global dialogue on national security laws as well. Well, on that note, I want to first thank you both for your very thorough and very helpful presentations and for the question and answer. Ladies and gentlemen, can you please show your appreciation for our two speakers?
再一次多謝楊教授同兩位嘉賓講者深入獨到嘅分享。論壇嘅第一部分到此結束，第二部分將會喺下午2點15分準時開始。屆時將繼續有關於香港國安法及維護國家安全相關法律嘅展望同前沿議題嘅主題演講同座談環節。再次提醒大家，請喺下午2點15分前回到會場。我哋下午再見。